We are going now from the high level, very high level, to slightly more concrete. And we have, I'm really, really pleased about the members of our panel this morning, Stanley Martin and Luke Johnson. Stanley Martin is a counsel at Fasken Law Firm, one of Canada's large multi-purpose law firms. He holds an MA in history and a Master of Laws from Cambridge University. And he's practiced in a number of areas, but his practice has included lots of matters involving litigation involving churches, internal and external disputes for various types of religious charities. Luke Johnson has also traveled over from the Lower Mainland to be with us. He is a partner at DeJager Volcanant. And I often call on Luke when I have questions about nonprofit and charity law. We served for a while together on the board for nonprofit and charity law when I was still in practice, and I've always really appreciated his advice and counsel around things to do with nonprofits and churches and foundations and private schools. So I'm really happy to have him with us. And Jody Sparger was going to originally had agreed to moderate this panel, and she unfortunately wasn't able to be here at the last moment. And so I'm very grateful and pleased that the Reverend Dr. Jason McKinney has agreed to step in for her and to moderate. He is an Anglican priest in the Diocese of Toronto and adjunct professor of theology at Trinity College. Also one of our speakers and participants tomorrow morning. So thank you, Jason, for taking us on really at the last minute, and I'll turn it over to you and to our panelists. Thanks.
Thank you, Kathy. I don't know if you recall this morning that Roshan, before he spoke, he said, I'm singularly unqualified to be on this panel. And then he proceeded to blow our minds. The first part remains true for me in this part, but not the second part. But we do have a series of questions for our practitioners of law, and they fall under several different categories. So we're going to spend about 30 minutes opening up that dialogue between them with some prepared questions. And then as we near the end of the session, we'll open it up to folks from the audience to contribute their questions. So the first theme that we'll explore is patterns of religious property holding in Canada, the broad theme. And in that, we have this question for you two to address. How do churches and other religious institutions typically hold property in Canada? Trust, freehold, sure, what have you?
Maybe, just to situate my response, I'm a solicitor, so I'm a paperwork lawyer rather than a courthouse lawyer. So much of my work is with dealing with religious organizations in terms of their property ownership or their governance issues, bylaws, that kind of thing. Charity compliance issues. That's the focus of my practice. So I think there's three ways that churches generally, or religious organizations generally hold property in Canada. Probably the most common is an incorporated society that holds property in its own name. So whether that's a BC society or an Alberta society or a federal nonprofit organization, it's a legal person. It owns property for itself. The less common ways would be an unincorporated association that holds property through trustees. So in BC, you can do that by having perhaps 3 human trustees who are the names on title. BC has legislation to say that someone has to own the property. And if your church is not an incorporated entity, then we need to have some humans listed on the title as the trustees, but they're holding the property in trust for the congregation, essentially. The third way that we see commonly would be having a national denomination or a provincial organization that holds property for a local church. The Pentecostal Assembly of Canada, for example, often holds property for its independent churches in any province. But again, the PAOC, for example, is an incorporated entity that owns property, dozens or hundreds, thousands of properties for its independent churches, local churches.
Well, let me situate myself, which I have always been a litigation lawyer, but I'm essentially at the end of that time in my career. But before that, I was a graduate student in history for a time. And what I found, the disputes I've dealt with have essentially involved episcopal structures acting for or against, or disputes within them. And particularly for the episcopal structures, you find these odd fossilized remnants of the old ownership structures, which came across from the United Kingdom law. And, you know, even structures like the Anglican diocese here, when you read the canons and the statute, use a whole lot of terms which are derived from an English background. I mean, there is a statute relating to the diocese here, which creates the bishop a corporation soul, and who knows what that means anymore. But there are a lot of terms used within those concepts. But essentially what has happened in Canada historically is that although not all structures are officially trusts, many of them incorporate one way or another essentially trust concepts. In the Anglican Church, when the Church of England first established itself in Canada, the structure was always that the church wardens held title on trust. And you still have church wardens, and they will hold the parish property, but not the real property, the financial property on trust. So we do see remnants of those structures, particularly trust structures, show up surprisingly often and lie behind the concerns the courts often have about implied trusts in relation to religious organizations.
The interesting reality, so I've given you a really bald summary of, you know, we have corporations and we have humans and perhaps a national denomination. But the interesting part of my work is that disputes can arise in all of those categories. And our topic is how do we resolve those disputes, or more my focus is going to be how can we avoid them? So the most interesting part of my work is that people have no idea their church holds property. I had a consultation with a church camp a couple of weeks ago. They have been a camp for decades. They have lakefront property worth some millions of dollars. Until they had a lawyer become the chair of the board, and he pushed for some investigation to see what the status of the property was. But until he joined the board, no one had any idea. They're not incorporated. They are an unincorporated association, and they don't really know what that means. They have a relationship with the denomination that is based on a 2-page document that's about 80 years old, that no one really understands. They have successfully had thousands of children through the camp and families. They have staff. They have a healthy bank account. They're a dynamic, active organization. But from a lawyer's perspective, it's quite striking to me that they have no idea what kind of legal status they have. There's an open question about who owns the property. Is it the camp's property? Is it the provincial organization's property? Is it the national organization's property? Is there actually a trust, or is there an implied trust? Or so my assignment, if they haven't hired me yet, I should say, but my assignment, if they hire me, is to spend maybe 6 or 8 months figuring this out, and then giving them a structure that will serve them well for the next few decades of work, right? This kind of uncertainty is much more common in the nonprofit sector, the charitable sector, than it is in other sectors. And so it's an interesting area to work in, because we have this unpredictability or uncertainty around who owns property. And at the end of the day, because these are generally charities, it's not the case that the individual attendees or camp leadership, they don't own anything at the end of the day, right? The charity owns the property and uses the property to accomplish certain charitable purposes. So it's not like a business corporation where at the end of the day, we could say the shareholders own it and have control of this property. Makes for a much more interesting problems to solve, in my opinion.
Well, from the litigation lawyer's point of view, the scary bit of that kind of structure is that you worry about tort liability and who would end up being responsible for it. But that's not our property concern today.
Issue is sort of a jargon alert. To define terms, if the lay audience maybe not doesn't.
Oh, a
understand
tort
the term.
liability. I'm thinking more specifically about abuse claims, which can arise obviously in the context of a children's camp. And there's a lot of law about who may be responsible for that. If you don't have a clearly set out structure of ownership, the responsibility can spread quite widely.
Or there's a high level of uncertainty. And so I have clients that are dealing with those kinds of claims right now. In some cases, they are unincorporated associations. And so it's not clear that the law around unincorporated association is decades old and fossilized. It's a good word for it. So are the members responsible? Are the members in 1974 responsible? Are the elected trustees responsible? Are the directors responsible? Hopefully there's insurance coverage to be responsible, but my file with the camp that has some uncertainty around this, they don't have a claim. There's no pressing need to resolve this problem, and they've operated successfully, as I say, for decades. But when lawyers look at these files, they tend to think, well, if there is a claim, how is it going to be resolved, and where's the liability going to lie? And is it going to take 4 years to sort that out on their behalf?
So maybe thinking about some of the trends that you're noticing in your respective practices, and this maybe gets back to the question that Tellison asked this morning. Are you noticing any changes in our contemporary moment, especially as the uses of some of these properties are changing? Housing prices are rising, congregations are decreasing, mixed use is becoming more of a practice. Does that raise any complications for churches or other religious organizations?
I can start. All of those factors are problematic. In Vancouver, I live outside Vancouver in Surrey. The issue of aging or declining congregations is a significant problem for churches. They often have deferred maintenance. They have valuable buildings with small membership, and they're looking at deciding what to do with the building. I missed some of the session this morning, but I think you covered some of that in terms of the opportunities for selling the property to a developer, giving it back to the national organization perhaps, or giving it to a fast-growing younger church in the neighborhood. Or there's lots of social housing development opportunities, that kind of thing. But I think the biggest problem is that churches are woefully under-equipped to deal with these questions. They have difficulty paying for. There are property development consultants who do this as their profession, and lawyers and accountants who have experience with dealing with these. But often churches have lay leadership who are not experienced with this. They have difficulty just grappling with the intensity of something like a property development. I have a client that is about 4 years into a relatively modest property development, about 70 units of housing plus an integrated church. And it's honestly overwhelming for them. Like the number of decisions to be made with the city of Vancouver and architects and consultants, et cetera, et cetera. Imagine a small board of 5 or 6 people, some of whom passed away due to COVID, some of whom have moved on from the church. So I think my it's a difficult intersection of really high property values. So the stakes are high and the risks are high, and limited capacity in the organizations, coupled with some really exceptional opportunities to build housing, to meet needs in the community, to provide childcare, to provide a building that could serve as a church for another 100 years. But it is so that, I mean, there's encouraging opportunities, but a lot of challenges for religious organizations dealing with these things.
Well, that's obviously right. But there are opportunities that are being missed as well out there, which is always one that concerns me. I mean, the problem, as I see it, in the inner city is we have a loss of public spaces because land has become so valuable. In the old days, there would be, a Russian community center and a Polish community center and whatever else every few blocks. And there were spaces that people could use for public purposes that nonprofits could use. And those are diminishing quickly. I mean, and so where a church is thinking, what does stewardship of our land that we've inherited involve? It's a very special opportunity. I mean, we had the description of the First United project on the downtown east side, which is showing what you can do. I'm on the board of Union Gospel Mission, which is just 3 blocks down East Hastings from First United. And we recently opened a women and families center that provides transitional housing. But we spent a year or more looking for any land that we could use, preferably a bit further away from the downtown east side, for that project. And there really was nothing available that was remotely economically possible. And there's a real shortage of land for the community uses, for nonprofit uses, for those kinds of things. And when a church has an opportunity to think of a way of enabling that, I think that is a tremendous opportunity. And I really hate to see those spaces lost and the public commons, so to speak, lost, which can happen too easily. The church I went to for a time, we spent 4 years renting a wonderful church building with a declining congregation. And it was a great worship space. There were community organizations. And eventually, of course, the diocese decided the best thing to do was sell it. And I don't want to criticize that decision. But of course, it gets sold for market housing because that was the best price for the diocese. And so that space is lost forever for that kind of public use, nonprofit use, or any use that's, consistent with the original mission of the people who gave the money to build that church.
Just insert myself here briefly because the parish that I am the priest at in Toronto, we've made that transition to essentially a community hub without any legal change or anything. It's just that we had a lot of empty space in the neighborhood of Parkdale. There's a highly served area, so there's a really rich kind of social service sector. Lots of small organizations that don't have affordable space. So now the space is filled by 5 or 6 value-aligned community organizations that help the church to pay the rent. So there are some. It benefits the church as well as the community organizations that need that space that is still aligned with the charitable purpose.
Well, I'm just delighted to hear that and to think about to see that those opportunities being taken.
So religious institutions often rely on donations by their members, and they use those donations to fund staff salaries, community activities, and even the purchase of other properties. Are there limits on the use to which religious institutions can put those funds to?
Well, there are 2 obvious limits. The first is that religious institutions are almost invariably organized as charities for the purpose of federal income tax law. And so the CRA likes to restrict charities to charitable operations. And so that's number one. That becomes a very practical issue if you want to put housing in. I don't know whether that's the place to talk about it, but as you may know, the charitable heads in Canada include relief of poverty. And so the CRA will accept that sort of a certain level of housing well below market can be regarded as relief of poverty, but they have a ceiling for that. And if you have too much of your housing development going for essentially market, if you're going for market rent or anything like that, it's not something that a church can operate. The second obvious restriction is you have to look back and see what restrictions, if any, the original donor put on their gift of money, and whether or not what you want to do is within those restrictions, if those restrictions are legally enforceable as trust obligations.
I can comment on CRA's constraints around charitable operations, which are somewhat delusory. I think it's quite straightforward to have your church change its purposes. So if your church has standard religious purposes to operate a church, something like that, if you want to add a purpose to operate a library or a food bank or provide housing or something, CRA doesn't care particularly at all. It's quite straightforward to make that change. Generally in BC, that means having your members pass a special resolution to approve a change to your constitution, which I think is not necessarily sound, in that CRA as the regulator could play a role in changes to or repurposing of charitable assets, but whether it's a capacity issue or CRA doesn't want to be involved in that, it's not really, they don't really involve themselves in that. So when clients ask me if they can expand their charitable purposes or pivot and do something different, generally my answer is no one's going to stop you. CRA is not going to stop you. If your members are in favor of it, then you can. But I do worry about the trust obligations that are tied to religious property. If you are a church and your property is devoted towards religious activities, is it fair or reasonable to repurpose that? Is it a breach of trust, actually, to repurpose that to focus on housing or environmental issues or something like that? But practically speaking, in terms of CRA compliance, the question is, will CRA stop you? And they won't. So,
so this is always interesting when one lawyer says that. Don't worry, CRA won't do anything. I have to say, UGM has, I'm on the board, when I say I'm on the board of UGM, I'm on the board of 4 different UGM organizations, because we have an operating charity, a foundation, and 2 separate housing corporations. And the housing corporations are not charities, because the housing operations we run through them would not qualify for CRA purposes. So we have been fairly rigorous about keeping that distinction, and there are CRA policies on when the kind of people you're housing are getting too wealthy for their concerns.
In BC Housing has thresholds for when, certain kinds of housing, and for some couples with families, say into a 3-bedroom unit, in some analysis, people making annual income of up to $180,000 can qualify as not as poor, but as people in need of supportive, people in need of housing, non-market housing. So imagine your family could be making $180,000 a year or something like that. You have 3 children or 2 children, you require 3 bedrooms. At least on some analysis, those people count as potential beneficiaries of charitable housing. So I have a client that applied to set up a new charitable housing organization, and it took CRA 2.5 years to review their application. Generally, it takes maybe 6 months or something like this. And so about 2 years in, I phoned the CRA officer who was examining this and said, okay, it's been 2 years now. Do you have an answer for us? And she said it had been forwarded to a special subcommittee internally in CRA to grapple with this question of what to do with Vancouver housing, charitable housing, because there are quite straightforward rules around what kind of housing is charitable and what isn't. But Vancouver charities in particular have been pushing the limits and almost daring CRA to stop them or shut them down, because it's clear that in downtown Vancouver, for example, people making $100,000 a year are not rich. And if they're spending $3,500 a month on rent or something, it seems quite persuasive to me that those people are arguably poor for the purposes of receiving charitable housing. So there's I'm not sure what the answer is, but the upshot of this, my client was registered. They were able to satisfy CRA in part because they focus on providing services to seniors, which is a different sort of avenue. But there's significant uncertainty within CRA about how do they resolve these questions around what kind of work is charitable and what's permissible and what's not. But it's difficult for clients to figure this out, and lawyers disagree, and even different people at CRA internally disagree about it. So it remains to be seen how that will be sorted out.
So maybe this one goes back to you, Luke, because you stated this is what you do. But what are some of the things that religious communities can do to avoid disputes or conflicts over the use of religious property?
Sure. The number one answer to that is to figure out what you are and who you are and what do you own and in what capacity, what are your responsibilities, what are your trust obligations. BC has relatively new legislation called LODR, Landowner Transparency Registry. So has anyone gone through the filings in the last year or two with their churches? Are you aware of this? The idea is to track down offshore owners or foreign owners or something like that. But churches and charities, nonprofits have been caught up in this. And so there's the lawyers had to do filings to say, who are the real owners of these properties? Which I think has been, this is an unintended byproduct, but I think was a fantastic mechanism to force charities and lots of people to look at their ownership and sort of see where they are. I have a client that is a gospel hall in BC. Gospel halls are often unincorporated entities, and so they hold property by way of trustees. All of their trustees had passed away close to 50 years ago. And no one had noticed, right? They hadn't, well, they didn't take out a mortgage, and so the bank didn't ask them about it. They didn't pay property taxes, so the city didn't ask them about it. I don't know, like there was no reason for anyone to look at this until the LODR legislation came in. So we asked them, are these people alive and can they sign the necessary form? Oh no, that's my grandfather. He passed away in 1964. So we cleaned up the organization. They have new trustees, and now they do an election every year to elect 3 trustees to hold property for them. But I think it's an example of, now, so imagine they had a sexual abuse claim that arises inside the church, or there's a difference of opinion about, do we do this or do we do that? It's time to close down the property. Do we give it back to someone? The trustees are mere title holders. They're just nominees on the title. But of course, if your trustees passed away decades ago, it really reveals that you haven't turned your mind to some of these critical questions about ownership and responsibility. So this is a classic solicitor kind of answer to a legal problem. Don't let the litigators get their hands on it and fix it on the back end. Do the work on the front end, right? Figure out, are you a society? Are you in good standing as a society? Who owns your property? Do you have any mortgages? Do you have, are you subject to rights of way from the neighbors? Is someone entitled to purchase your property if you sell it? Have you committed in your constitution that when you wind up that you're going to give your property to the national organization? Does the national organization still exist? Do they want your property? So the framework, I think, is to do that Oh, and the other problem with this, of course, is that boards rotate every 2 years, 5 years. Fresh crop of people who have no idea, again, what the structure is. So I guess just do the homework, right? Plan, figure out what your structure is and what the ownership is. What are your obligations? What are the responsibilities? It is the case sometimes that there was a donor in a will who imposed obligations decades ago, but it doesn't really matter from my perspective if the obligations were imposed last year or 50 years ago. They're still trust obligations, right? They still may apply to the property. And if you don't know what they are, then you run into these problems of just not knowing. It's hard to make decisions unless you know where you're starting. So.
I have to agree that it's much better to talk to Luke first than a litigator afterwards.
So we'll maybe take two more questions on the panel here, and then we'll open it up to everyone else. So on trust law basics. So if a church holds property in trust for one purpose and then wishes to use that property for another purpose, is there a way that you can make that work?
To a limited extent, yes. And I'm tempted to really explain. This is the question that Professor Can passed over this morning to lateral to us. I'm tempted to get too technical on this just because I get enthusiastic about this stuff, and I'll try not to. But if a church holds property, whether it's its real property or whether it's a fund that somebody has given them on a charitable purpose trust, so it's not a trust for people, it's the donor has named a purpose for it, then if it becomes impractical or impossible to carry out that purpose, the courts actually have a jurisdiction to change that. And they say, well, there was a general charitable intention in the person who gave you those funds. It doesn't work now. We're going to change the purpose to something as near as possible, but which is practical. And in law, it's given a name, that jurisdiction is given a name which comes straight out of medieval law French, which is si pre. You don't have to worry about that. But I've been involved in a couple of those situations. They can change the trustee in some cases, or they can change the trust. Sorry, not change the trustee. They can respect the character of the trustee. I did one case for a university where they had been left a very large bursary fund, which only sort of fell into the university years afterwards for complicated reasons of life interests. And when they looked at this, the will, it had been written by somebody in an earlier history of Canadian bigotry and excluded Roman Catholics, Jews, and was in fact restricted to British subjects. And the university in question looked at this in horror and said, we can't administer that, quite frankly. So I ended up going into the Court of Appeal and saying, could you fix the problem? And they applied the si pre doctrine and said, well, it was important to the donor that the trust be administered by the university. And that's the only practical thing to do with the bursary fund. So we'll change the terms of the fund to make it something that the university could administer. So they wrote out all the discriminatory provisions. In the church context, I was involved in a case where there was a Catholic congregation, a Chinese congregation church in Vancouver, and it was mandated as part of the parish that its mission was to the Chinese community. And a member of that congregation moved back to Hong Kong, died a few years later, and left a huge bequest to the church's building fund. The church owned a parish church, which was this is the opposite of the usual problem. Its parish church was too small for it. So they had found another church who's an independent church who had a small congregation but a large building. And they had done a deal where they rented each other's buildings. Then there was a dispute within the diocese, which led to the congregation of the Chinese church deciding to leave the diocese. And the court decision in relation to their real property was that it remained with the diocese. But that left the problem about this bequest to the building fund. And the court looked at it and said, well, basically the 3 Chinese congregations the diocese had all left. There was no prospect that the diocese would ever build a building for the Chinese community. The donor had really intended it to go to the benefit of the congregation as she knew it. And so they changed the terms of the trust so that the benefit of that bequest went to the congregation, even though it's leaving the diocese, rather than going to the formal parish corporation structure. So the courts are flexible. I mean, they're not originalists like certain members of the US Supreme Court. I mean, they're much more in line with the kind of concept of a living tree. And this is also apparent in the cases I've dealt with, which deal with mergers and splits in churches, where the courts are concerned not to constrain churches to doctrine as it was understood in 1850 or something. But if the church has a formal process and procedures and tribunals to determine changes in doctrine, then the courts will respect that. But there's a limit to this, and it's the unfortunate fact that in British Columbia, there is surprisingly no statutory law of charity. Whereas, say, in the UK, you have a Charities Act. And in the UK, the courts have quite a broad jurisdiction, statutory jurisdiction under the Charities Act to figure out what to do with funds like this. And it's much broader than the CPRA jurisdiction here. So there is a limited amount the courts can do. It's not as much as I think they should be able to do, but that's where we are today.
BC also has, in theory, the Attorney General of BC has some responsibility for these kinds of questions, or at least some interest in that. But as far as I know, the Attorney General is not interested in this whole area, and so doesn't really involve themselves.
Well, the reason for the AG is that the AG, if you have a purpose trust, the question is who can complain about it or go to court. And if the trustees want to do it, that's okay. But if the trustees don't, then the only person who can show up in court is the Attorney General in exercise, and this does get technical, in the exercise of the parens patriae jurisdiction.
Jargon alert.
But which brings me back to my point from 20 minutes ago, like if no one can complain, is there an obligation? If CRA doesn't care, if the Attorney General is not interested, I think by comparison, the Attorney General in Ontario generally sees this as part of their responsibility. So in Ontario, the situation's a bit different. The Attorney General provincially does interest themselves in some of these questions, but there's a bit of a vacuum in British Columbia.
And Ontario has a Charities Act, which we don't.
We're jealous.
So maybe one final question for the panel, and we're going to move to the question of land back initiatives. So in a few cases in Ontario, churches have transferred land back to the Indigenous communities who lay claim to those lands. I'd be curious what some of those examples are personally. Is this happening in BC? And what are some of the things that a religious community who's interested in a land back initiative would need to address?
I've never had clients ask about it. I've never had any clients do this or propose to do it. In researching, I came across an example of, I think, the Catholic organization in BC transferring a small island back here in about 5 years ago to a First Nation on Northern Vancouver Island. But I wouldn't say there's momentum around it or significant interest for religious organizations. Most organizations that feel that their tenure on a property is coming to an end, as Stanley has said, they look at selling it for market housing, or perhaps to another related church, or to another a Muslim organization, a Buddhist organization, a daycare. But I don't think I don't think they've particularly turned their mind to the thought of whether we should give the land back. So the factors I think that churches should think about that would be, or religious organizations generally, like, do they have a pre-commitment, say, to their national organization or to their provincial district or something like that, where actually they have made this decision already 50 years ago in terms of deciding when the organization winds up, are we going to transfer the property to someone? Generally, that would be a national organization or an affiliate church in the same city or something like that. But I like the idea of a land back transfer in the sense that it is very clear cut and straightforward. It's not philosophical or esoteric. It's transferring the real estate back, which I like. I think it exposes the hypocrisy of a lot of people who have nice ideas about this, but aren't prepared to follow through, aren't prepared to put their money, their property where their mouth is, right? Because for religious organizations, the property, the church that they use is, some of them hold on to it fairly lightly, but in many cases, they've been there for decades. My grandpa was a pastor. He built his church like literally with his own hands. So he had and he was there for 50 or 60 years. He had a really significant investment in that property. So if that property were to be transferred back to the local First Nation, this is in Saskatchewan, that would be a pretty significant statement from a church about their commitment to that local First Nation.
Yeah, I mean, I would agree with all of that. I don't think there would normally be any legal impediment to doing that. You'd have internal institutional rules to follow, and but there might be other considerations. But if you had a trust which restricted the use of the land, you'd have to address that. And that's the kind of thing that a court could address if you needed to sell the property. So I think it's a question of will and intention rather than law.
Yeah. Most First Nations are qualified donees, meaning that charities are one type of qualified donees, also the UN and some other organizations, but generally First Nations fall into that category. And the significance of that from a CRA perspective is that qualified donees can transfer property back and forth from one to another. So CRA is significantly concerned if you sell your property to a developer, if a charity does, because they ask themselves, are you getting fair market value? Is this a private benefit to the developer because you're selling it 50% of fair market value? But if you transfer your church property to the local Vietnamese church, CRA doesn't really have anything to say about it because they're both charities, right? The fair market value of that transfer is not a relevant consideration.
I don't know if this is the example referred to in the question about Ontario, but I know that out of the Six Nations of the Grand River Reserve, there's a movement that's brewing with Rick Hill and Adrian Jacobs trying to develop spiritual covenants between First Nations and churches. And there's a specific interest in working with churches because churches are not entangled in the property tax system. So it makes for a much smoother transfer. So it's an easier process, but it also, I think, speaking as a representative of the church, it puts an extra burden on the church to think more deeply and theologically about that possibility of land back. And the practice that they're trying to implement is just to enter into a lease agreement. So to acknowledge the sovereignty of the local First Nation, essentially hand the land back, pay a token lease amount until the point of disestablishment, and then the land goes back into the First Nation. But I think there hasn't actually been an example of that following through yet. I think there's a few that are sort of in the pipeline. But yeah. Are there questions coming from any of you? There are a few.
Yes, following up on our moderator's conversation earlier, it would seem to me then that the United Church of Canada that somehow is stalling on transferring the land that the church owned on the Bella Reserve to just get on with doing it. So my question, I think, to you is, well, to all of you, but including our moderator, is in a month's time, the Pacific Mountain region, which is the local region for a body for governance of the United Church, is meeting. And can we just put a motion on the floor to get off our butts and give that back?
Sorry to hijack your panel. Yeah, so yes, absolutely. Our polity allows for that. And like I said earlier, one of the benefits of how flexible things have happened with shifting to the proposal thing is I wouldn't make it specific to Bella Bella. I would just say, you know, in reflecting on all of these principles that we've talked about this weekend, and you could write that up in the purpose, that the United Church of Canada should discern where we have fee simple title on land held within reserves and direct the executive minister to arrange to have that land returned to the tribal councils that are owning the reserves. And I think probably things have changed. It depends on the circumstance of the actual tribal council. Like in Bella Bella, we've won a couple of really huge court cases where we have a significant amount of unrestricted assets now, which is not generally how the Indian Act economics were set up. It was all fund accounting. And so you couldn't have surpluses, so that the government had really strict control over what you could and couldn't do. So in Bella Bella, like we could probably just do a fee simple thing, especially given the, like, I don't know, you'd have to talk to a lawyer, but you could probably also consider selling it to them for cash. But like, I think it should be resolved either way, whether it has to go back to Indian Affairs first, or it can go straight to the tribal council. It still doesn't make any sense for it to happen the way it is. And I think it would be great if the church called on the region to start that and shared with your reconciliation matters committees in other parts of the countries to do it in the other 16 regions. Well, actually not the National Indigenous Council, because
Send me what you just said, so that there's 3 from our church going, and I think we can get that going easily. Sure. Thank you.
If I can do one technical insertion, the most lots in BC are part of, I'll simplify, like most lots are fee simple, meaning that the Crown owned it once upon a time and now it's owned by A. And so for A to sell it to B is just a matter of doing a filing with the land title office, and now B owns it. But the reserve lands are different. And I know this because someone asked me to do a transfer on reserve land, and I looked at it, and then I looked at it some more, and it got too complicated. And I said, you need to find somebody else to do this. So the fact that that most lots in BC can be transferred in a fairly straightforward way doesn't necessarily mean that reserve land can as well, particularly if there's, say, a mortgage or right of first refusal or other filings on the title. So I don't mean to imply that the United Church is stalling on anything. I mean, it can be fairly complicated to accomplish this.
yeah, I think in the circumstance that I talked about this morning, it's not, I wouldn't even say that it's stalling. It's not an intent. I think it's a consequence of the diminished administrative capacity of the church too. But hypothetically speaking, if the Heiltsuk Tribal Council said, okay, there's no mortgage, there's no right of first refusal, it was a simple thing. Could also the Heiltsuk Tribal Council just buy that land back without having to go through INAC?
I don't know the answer to that question. In terms of reserve, I've only dealt with one reserve that has, or one First Nation that has essentially set up a parallel land title office. So we have a BC provincial land title office, and then they have their own land title office. This is in the Okanagan. But it's almost exactly the same as the regular BC land title office. Just you do your filings in their, for their jurisdiction, use their land title office. But I'm not sure if that would apply to that particular First Nation or not. So If someone knows, you can enlighten us.
Yeah, so, I'm a lawyer. I'm not a very good one, but you know, I have worked in this area a little bit. And so if the land, if it is on reserve land, part of reserve land, then it is actually, it all goes through Ottawa. But if the Celtic and the United Church both agree, if it's either a sale for whatever value or not, it can either simply be, it's an addition to reserve or it's a simple transfer. So it's again, it's a administrative problem, not a conceptual problem.
I was interested in what you do when the law conflicts with the theology of other religions, because the charity law is very much rooted in Christian theology. But if you have a Islamic charity that wants to do Sharia compliant finance, I mean, that runs afoul of the, business activities. Or if you have a mosque that wants to do Islamic burial properties, where they, own the lots for decades ahead and do it very differently than the Christians, how do you move in that?
I don't know that I could say I've come across a conflict yet. We have many Muslim, Buddhist, Hindu organizations, but in most cases, they seem to be able to navigate, or we help them navigate the Christian religious legal structure in a way that accommodates what they're looking for. So particularly to come back to our dispute resolution framework, like they have the same kinds of arguments that Christian churches have, and they tend to be resolved in the same kinds of ways. So I don't, maybe it's just I haven't come across those problems yet, but in most cases they have the benefit of the same legal protections: property transfer tax entitlement, property tax entitlement, donation credits, etc. So they're able to draw on these traditions in many ways, or these protections. But I do see how they could come into conflict in certain ways. Just haven't had to deal with that yet. Have you?
I haven't come across a conflict yet, so I'm not sure what I could add to that one, except to say, I mean, the Canadian law recognizes a much broader concept of religion than it did when the original charities law was instituted. So the courts would try to accommodate where they thought it was reasonably appropriate, but I haven't had to deal with it myself.
Is there a difference between the transfer of title within the fee simple model or the transfer of title from the fee simple model into First Nations land model? I wonder about things like zoning, development permits, etc. If a church wanted to transfer land in an urban settlement right back into the First Nations model, would that land in an urban settlement, having been transferred back into the First Nations model, would it be subject to taxation, to zoning, to planning, to development regulations of the municipal government?
That's not within my area of expertise, I'm afraid. I don't know the answer to that question. You could perhaps duplicate that by way of a contract. So you could put a charge on title or certain ownership rights in the same way a mortgage could be filed on title. So you could reproduce it. You could do it yourself, which we've seen some organizations do, but I'm not aware of how you could integrate that lot into a First Nations in a different location.
Time for a couple more questions.
Thank you. My name is Siba Hualatangola. It means that I mirror the ways of my grandfather. I am Kwakwakiowak from Alert Bay. My English name is Yvonne Gesinghaus, and Gesinghaus because my father is German. This is a question on both potential dispute and hopefully avoidance. And it's concerning Alert Bay and Christchurch. In the late 1800s, around there, a lot of the Indian reserve lands were transferred to the Anglican Church. There's probably a good chance that there weren't any conditions written on there because the Anglican Church had some pretty high standards back then and things were just handed to the church. We just believed in it. Now, over time, parcels of the property that was taken out of Indian reserve land, given in fee simple to the church. Over time, the church sold a lot of those parcels of land to individuals. About 20 odd years ago, the remaining parcels of land were returned to the Namgis First Nation. In future, I can see our future leaders standing up and saying, hey, what about these other 100 acres or whatever the amount of land was? What about the rest of the parcels of land that you sold? Would the courts, have they experienced something like this before? How would they calculate the amount of restitution? I know we can't go and take the property away from the people that own the land now. So we need restitution. And to the other lawyer who's lending us his expertise, additions to reserve, is it still about 14 to 18 years to get it put onto reserves? Thank you.
Maybe I can answer. Go ahead. I have a backhanded way to answer it.
You try your backhanded way first.
I have a church client that is a BC society, and they lost their society status because they stopped doing their filings. So in BC, that means the land escheats or flows to the crown. And so my task was to get the property back to the society, the church. And so there's an provincial office that deals with this. And so I phoned them and asked, do you have any, in theory, the crown has a role in this kind of transfer, although in reality, BC doesn't particularly want this piece of property. So they told me there's two options. You can do it this way, which means you need to provide notice to all the local First Nations who might have an interest in that property, or you can do it that way, which means that you don't have to give notice to the local First Nations. And so I did it that way, which meant I didn't have to give notice to the local First Nations because my client was worried about being caught up in a 10, 20-year process. But the provincial officer made it pretty clear to me which choice I should make, which doesn't directly answer your question, but I think hints at that was 10 years ago probably. So it probably shows how that particular BC office thought about some of these kinds of questions. And I wonder how the property owners who are there today, or how would they respond? I can't give any assessment of your litigation chances or the restitution options, but there's a pretty significant institutional disinclination to do anything about this.
I certainly couldn't comment on that situation without knowing enormously more about it. There's a typical lawyer's response. But there's some interesting things that have happened in the courts. And the one which is a little bit of a parallel is in Vancouver would be the Kitsilano railway lands, which were cut off from the reserve 100 years before. CP built tracks along it, abandoned the tracks. And then the claim, which was upheld by the courts, was that there was a resulting trust. In other words, when the original purpose for which those lands had been taken ended, that they reverted to the First Nation in question, which they've done, and that's the land that's being developed by the Burrard Street Bridge. So there are at least suggestions in the case law that there are obligations there which spring up when you've had reserve land taken out of reserves for a particular use and that use has ended. I'm not proposing a litigation strategy because that's too much. I'm just saying that there are ways the courts have thought about these things. They haven't just said no.
Maybe we'll take one more question.
Okay.
Go ahead, sir.
Okay. If David Soljak last night and recent history is any indication of the 1.3 new immigrants that will come to Canada in the next 3 years, 48% of them will be Christians. So over 600,000 new people. And after listening to you this afternoon, I have no confidence that the church is ready to receive them or even order ourselves if we can't really find a verification system of discovering whether trustees are dead or alive. It's exciting that that engagement will happen and that we can prepare for that. But are there any ways that you would suggest that churches and denominations should be more self-reflective of analyzing or assessing where they are? Is it social return on investment? Is it ways of describing, as you've described, Stanley, the listing of so many things that happen in public spaces that are still necessary to continue? So what are the ways in which churches can non-defensively describe what they do to the benefit of the larger community? And would you have any suggestions in those matters?
Jeremy, that's really interesting. I haven't yet seen a denomination actually sit down and say, we have this property and this is the things we do with it today and these are the things we can do with it. But as an intentional exercise, it would be wonderful to see that.
I think that this is a good time to have that conversation after COVID, because I'm not sure about your organizations, but many of the churches and religious organizations we work with are down 30, 40%, 50% in terms of attendance after COVID. And so they're open to ideas, actually. We're out of COVID now, more or less, let's say, I don't know. But they're looking at their assets, looking at their activities, reassessing their strategic plans. So it makes me think there's a church in Surrey that has everybody likes Seventh-day Adventists because they use the church on Saturday, right? So they've got the Seventh-day Adventists on Saturday. They've got the regular church on Sunday morning. They've got Cambodian congregation, Vietnamese congregation, Fijian congregation, like you name it. There are, I think, 8 groups cycling through on Saturday and Sundays, plus dozens of other things happening during the week, right? So churches are open to these kinds of opportunities. But it is difficult for denominations. Like, these are big, slow-moving organizations. It's hard for them to grapple with the opportunities and the questions, and limited capacity, as I say, for reflection. So I think churches are working on it, and they're open to interesting ideas and changes and stuff, but it's not easy for them to wrap their heads around.
One last question.
I wonder whether there are implications in this panel also for the ethics of giving. One of the things that was a theme in this panel was the extent to which trust obligations that were determined long in the past continue to shape, unless they prove to be utterly impractical, what can happen with those resources today. And I wonder whether that really should be a lesson to people giving to religious communities, to be careful about the extent of conditions that are imposed. I think often when gifts are given, there's a tendency to want to articulate what is the ideal use for that gift, that then ends up constraining the institution long into the future, way beyond the conditions that produce that desire. But I think it also has implications for the question of land bank as well, or for the transfer of church property to other uses. Often, in the very act of giving, the power of property is also exercised in attempting to protect something that one cares about very much with respect to that property today. You can have the land back, but you must keep that building. on that land. And I wonder whether there is a kind of letting go that ought to be part of the ethic of giving that would actually make a lot of the things that we're discussing here less difficult, less challenging, would allow the institutions themselves to respond to changing needs.
Well, speaking as someone who sits on more non-profit boards than church organizations, I mean, for a long time, we have encouraged people not to tie up their donations that way. And I mean, I fully agree with you. I mean, it's sometimes a donor really, really wants to tie stuff up that way. It's very hard to say no to the money. You don't. But you encourage people to see the bigger picture and say, look, we don't know what we're going to be doing in 10 years' time. We want this money to continue to be used for the general mission that we're engaged in. So I'm fully with you on that, in general terms, I think unless there's special circumstances, there's a lot to be said for general giving rather than what is, let's face it, a trend in the philanthropic area of donor-directed giving. That's not my area, and I'm very conscious I've got Blake sitting there who knows more about this than any of the rest of us. But I like what you're saying.
Yeah, I agree with that. This is one of those questions for me that depends who my client is, because if my client wants this, say, and I tie up the funds for them as tightly as possible. If my client is the organization and they want unrestricted access to the funds for general uses, I do what the client wants. But in many cases, what the client wants is not a great idea. So I do try and work with the donors to see the value of building in some flexibility, some options for the future.
Well, thank you to our panel. Thank you to all of you for getting through the late afternoon slump. And let's offer a word of thanks to our panel.